The topic that has been given to me today is criminal laws and gender justice, which is very relevant. But I thought I'd say a few things linking from the previous talk to this one. Broadly speaking, what we are going to do, why criminal law exists, what the purpose of criminal law as seen by society is, what we mean by the public-private divide, that is how criminal law works if it is a public offense in the public domain, and how it works within the home. Special laws for women, and whether these are truly special and whether they are actually to the benefit of women or not. And while dealing with special laws, we will also look at POCSO, which was one of the questions which came up here, and kidnapping and child marriage, to see whether the laws as they exist are actually beneficial to women or not. And we look at some of the modern trends that are there in criminal law in India, specifically on gender. And these are not, because we are trying to look at it critically, these will be trends that we should look at from a critical perspective. And lastly, what do we mean by procedural justice for women in the criminal justice system? Because criminal law, as we know, is not just bare acts and cases, but also the procedure that is followed in law, and whether that is brings justice for women. I just wanted to have a preliminary note on gender. You have already had, I think, in the previous session, dealt with what is sex and gender, so I won't be going into it again. And we do know that there are wider meanings now, and law is being challenged by the LGBTQAI community, because law has traditionally been set in a very binary system. So even criminal law keeps using the terms man and woman, he includes she, and so on. However, we know that the way that people experience violence might be very different, and criminal law has to adapt to address that violence. And I'll just give one example. There was a trans woman who had complained of rape, and in the police station they were confused, saying that how can she complain of, how can they complain of rape, because rape is very specific to women, and you have of course the earlier 377 and its equivalents which men can use. But she wanted to use a rape law, and the police said that, but you're not a woman, how can you be raped? And so they asked an NGO to represent them, and the NGO had to do like a sensitization for the police, and finally a rape case was filed which recognized her as a survivor of rape. So unfortunately, even now, criminal law is largely set in a gender binary. So the talk will largely be on the law as it applies to women. Okay, but we will look at some of these other issues, and if you feel some of these issues need to be addressed, you can follow it up in questions. So I hope I will be able to keep enough time towards the end for questions. Now, when we look at why we have criminal law, we know that first of all, without criminal law, acts cannot be prohibited. So, for instance, you have a difference in the way that criminal law provisions are framed and moral provisions are framed. So, in most communities, you have codes like "you shall not kill." So, killing is a moral wrong. But many communities don't prescribe a punishment for that killing, right? Is there any community which says you shall kill? No one says that, right? Everyone says you shall not kill. So when you say you shall not kill, there is no punishment attached to it. It is a moral code. But does the Indian law say you shall not kill? Does the IPC say you shall not kill? What does it say? If you kill, this is the punishment. Nowhere in criminal law is something prohibited in that sense without a punishment. Okay? So it just says if you do this act, these are the consequences. Now, why does it say that? Why does it pick up certain acts? So certain acts are prohibited because they consider detrimental to society. And there might be some acts, for instance, which may be considered detrimental in some societies, but not considered detrimental in other societies. Can you give me an example? Something which is a crime in some places, but not a crime in other places. Huh? Marriage. Polygamy. Okay, polygamy may be a crime in some places, not in other places. Abortion is a good example. Is a crime? Huh? Arms, for instance. Huh? Gender. Okay. Female gender. FGM. Yeah, might be a crime in some societies, may not be a crime in other societies. Can you think of crimes that are acts that are crimes in some parts of India, not in other parts of India? No? Selling alcohol. Some states which are under prohibition, you can't buy alcohol or sell it. Okay, so please don't move to those states. So that can itself be a crime in some states, in other states it's not a crime. Marriage under the age of 21 is a crime, maybe in a state like Himachal, but for other states it is 18. Okay, so you have these different provisions about living in without getting married. It's not a crime anywhere except in Uttarakhand, where if you live in for 1 month, you can be imprisoned for 3 months. It's a totally ridiculous law. Supposedly a uniform civil code. But these are laws that are in India which treat people differently. Okay, where some acts are punished in some places and considered crimes in some places, whereas in other places they may say this is nonsensical, this should not be a crime. Now, why do you have crimes? Listed down by the law. The first reason is, of course, deterrence, under the belief that if some act is criminalized, there will be a deterrent in society that people may not necessarily do that act. That's an argument which is limited. So even if you have the death penalty, for instance, for murder, people still commit murders. So there might be a deterrent effect, but it's not an absolute deterrent effect. The other reason that you have criminal law to punish is retribution. So someone has committed a crime against me. In earlier days, what would I do? I would go along with my people, if we are strong enough, and commit a crime against them. Okay. Huh? When countries do it, it is war. When individuals do it, it is taking the law in your own hands. So that doesn't make sense at all, right? And if I'm weak, then I don't have people backing me. I can't go and beat the other person up. So then law becomes really, or justice becomes only some remedy for the strong. So that sense of retribution that people want, that someone has done something wrong to me, I want them punished, is something that many people have. And so since they can't be vigilantes and go and do something by themselves, they expect the state to do it for them, okay, which is the right way. So retribution through punishment is one of the ways by which this is done. There is also the case of rehabilitation of offenders, that someone has done something wrong and that person must be rehabilitated. You should make sure, especially in the case of younger people, they have a chance to change. They must be given, they must be taught that this is wrong. And so rehabilitation is also an important part of criminal law, especially for the young. And the last is to prevention of potential further harm. That if someone is, let us say, a serial killer or a serial child abuser or a serial rapist, locking them up might prevent further rapes or further child molestations or further murders. Okay, so there are many reasons why this particular area of law exists. Now, when we look at the point of gender equality, this is not really very big in criminal law. The purpose of criminal law, when you ask people, these are the responses you get. Nobody ever says, oh, the purpose of criminal law is gender equality, because it is not. Okay? And though we see that this is not the purpose, and then you may have criminal laws which specifically deal with issues of gender, like gender-based violence. Okay? But we also see the darker side of criminal law, where criminal law has often been used to take away the rights that women have. That criminal law has often been used to increase the differences and the discrimination that women face. And there are many examples of this. Abortion is one of them that for a long time was penalized and continues to be penalized. That when there is an unwanted pregnancy, men don't bear any of the burden of that. For a young girl in school, for instance, if she faces an unwanted pregnancy and she doesn't have access to abortion, her life is over. She has to discontinue her education, she has to start working early to bring up this child, and she doesn't have many options. Her life chances are slim, as also the life chances of this child that is born, because nobody is going to support her or the child. And this is something that has been raised very often, especially in the United States in the recent past, that not giving women access to abortion affects not just her but also the child. They say that people who are anti-abortion are not pro-life. They are just anti-women's rights and anti-child rights. Okay? So the same government, you see, where abortion was criminalized or not allowed, they have cut down on things like child care, they cut down on welfare measures. So the children who are being born, these unwanted children who are being born, have no support really. Okay? So abortion is something which is very problematic if it is not allowed freely. The other problem is also that if women don't have access to legal abortion, they will resort to illegal abortion, in which case they may be themselves at risk. Okay? They might die, they might have severe health problems for the rest of their lives. Okay? They'll be forced to rely on quacks or people who are not qualified to perform very risky procedures, and this is something that we must avoid at all costs. It is, of course, a burden that is especially on women, because as I said, having an unwanted child is a burden that women face alone. Okay, men don't, who have also been responsible for that, either through a consensual sexual encounter or through rape, are not really liable. The other is, of course, we've seen in criminal law in India, things that have been struck down by the court, like the penalization of adultery, where the adultery of the wife was a crime, but the adultery of the husband has never been a crime. Okay? And why was this unequal position here? Because women were often seen, or wives were often seen as the property of their husbands. And so it was literally like, you're trespassing on my property, so you should be penalized. So these examples from criminal law show that it's not that, first of all, it's not that criminal law promoted gender equality in a very big way, but there were also cases in criminal law which did the opposite. Okay? Now, there have been cases also that we have to keep in mind, which, when you look at this, what is called the public-private divide, what happens in the public sphere and what happens in the private sphere, laws treat things very differently on the basis of gender. So when you look at this public-private divide, we see that crimes that happen in the public arena don't become crimes when they are in the private arena of the family or the home. Yes? So because of that, we see that there have been exceptions like the marital rape exception. It says that if a woman is raped by a stranger, it becomes rape. If the woman is raped by her husband, it is not rape. And what is the logic in it? Okay. This also stems from the fact of how, how sex is seen, to draw from the previous talk. that it is seen something that, men take sex and women give sex. And the role of the wife is to provide sex on demand. But that is not the role of the wife. Okay? That is maybe the role of masturbation, but definitely not the role of the wife to provide sex on demand. Neither is it the role of the husband to provide sex on demand. So sex is generally should be something that is mutual and which is consented for mutually. Okay? So having a marital rape exception is extremely cruel for women. So it says that if a stranger rapes you, you can take action against a stranger. But if your own husband, who's a person who should be, with whom you should be having voluntary sexual intercourse, if he forces you, then you don't have a remedy, at least under rape law. You can still file for assault, battery, etc. if it was a violent rape. So these are, this is the difference which exists in the public-private sphere in law. Okay? But there are many differences in the public-private sphere that exist, which are not laid down in the law, but in the way that society conducts itself. Okay? So one big example is violence. So many girls face violence when they are young. They face violence in adulthood as well. And what is the social understanding of violence within the family? It is seen as a right the parents have. And sometimes it is seen as a duty that the parents have to inflict violence upon the child so that the child will behave in a way that is desired by the parents. While both boys and girls face violence in childhood, for girls especially this violence continues into adulthood as well. And when this happens in the private sphere, nobody complains about it. So for instance, you come across a newspaper report that a teacher has beaten up a child. It becomes big news. Everyone goes to the school. They demand that the teachers be sacked. But if it happens in the house by parents, does anyone say anything? No. Why? Then it becomes a family matter. There's no such thing. Okay? There is no such thing as a family matter. It's not that when you enter your house, it's no longer India. It is still India. Your constitutional protections and your legal protections continue to exist within the home. But for some reason, because of the way we are socialized, the house is considered as a sacred space which is ruled by a tiny little king who is the head of the family, and what he says goes. But that is not really the way that we should be looking at things. So there is this huge difference between the private sphere and the public sphere. That what is not accepted in the private sphere is accepted in the public sphere. So someone who's, for instance, if one of your classmates comes and beats you up, you will immediately complain either to the authorities or to the police or both. But if your parents beat you up, it's very hard to complain. Okay? It's very hard to do anything about it. And young people who face this abuse, as we heard from the earlier speaker, it is very cyclical, and sometimes the cycle of abuse continues from generation to generation. Okay? So this public-private divide in criminal law is something that really impacts women getting justice in many ways. Most violence is, as we say, private violence. When we look at domestic violence, which is the second point here, for instance, we see that in any given society, 40 to 60% of women face domestic violence. Wives face domestic violence. Okay? What are the number of cases under 498A, which is cruelty to the wife? Hardly any, maybe 0.001%. Okay, so most women do not complain when they face violence within the house. Okay, so it's one of the most underreported crimes. On the other hand, we see that because society considers this private violence as justify, or as I said, rules in India don't apply at home, we see that often they try to also undermine good laws that exist. And one example of that is what we call 498A, which is now a different section in the PNS. Now, all the 498A says is that when a married woman faces cruelty, severe cruelty from her husband or the husband's relatives, it is a crime. That is all it says. Okay? But look at the furor against 498A. They keep saying that 498A is being misused, 498A is being misused. And if you look for searches on 498A, the first few searches, because you're looking at the way that the algorithm works, the first few searches are not, like sites which tell women how to get help when they face violence at home. What are the first few sites about? How 498A is being misused. Sites of men's rights organizations which say that 498A should be removed, which means basically that you should allow for cruelty against wives, is what it means if you remove 498A. And that, the examples given are of how different women have misused these laws. Now, every law can be misused. For instance, traffic violations. If you look at, the traffic violations, when a red light comes, what do most people do? Really? Which city are you living in? Huh? Let's see, is there a camera? Is there a cop? And then they will anyway move. Okay? They will take a judgment call of whether to follow the law or not. So we as a country are not a very law-abiding, nation. And so when you look at these laws, they are misused. Other laws are also misused. False cases are filed, for instance, for trespassing, for cheating, for so many different things. But when it comes to cases of gross dealing with women, then people say, oh, this law is being misused. Every law has potential and is being misused. But why are people picking 498A? Because of all the laws that exist, that is indeed one good law for women. Okay? 498A is an extremely useful system for women. Now, unfortunately, the criminal justice system is not always suitable to the free agency of women. What do you mean by free agency of women? That women decide that, okay, I want to file this case. Okay, I want to do this. Okay? So, generally speaking, criminal law has treated a woman as an appendage of a man or the property of a man, which is why you have a matrimonial case, exception, and so on. So, recognizing that women are independent beings with voices of their own and that they are able to exercise free agency is not always supported in criminal law. Now, to take one of the examples that one of you said, where a minor girl and boy are in a relationship. Who was the person who said that? Okay. So, if there's a minor girl and boy in a relationship with mutual consent and they are caught, who gets penalized? The first question is, should they be penalized at all? Alright. It is taken for granted that children are also sexual beings. There's not a button that you press when you're 18 when you suddenly become sexually active. So children are also sexual beings, and so if two children are engaged in some kind of sexual activity, should it be punished or not, is the first question that we must look at. Okay? Now, in the POCSO, which is a gender-neutral legislation, if a girl and a boy are, who are, let us say, 15 or 16, are engaged in some sexual activity, it doesn't have to be sexual intercourse per se, both of them are the victims and both of them are the offenders. However, because we live in a very gendered society, it is automatically presumed that the girl is the victim and the boy is the offender. So the Center for Child in the Law at the National Law School has a desk, represents a lot of these young boys who have been involved in what are called romantic cases, where the activity has been with consent. They have not raped anyone. And for them, these boys too were very young in school, to be just picked up and then put into the school is very traumatic. They are away from their families, their education is disrupted, and the cases sometimes take such a long time to be heard. And by the time the child loses, all hope within the criminal justice system. So these are very problematic when we look at, how the law treats these young people. And it's because of POCSO, that POCSO automatically makes it a crime. So it's criminalized a lot of situations which should not be done. A few months back, there was this newspaper report, I don't know if you came across it, where the school bags of 15-year-old students in a school were checked. And in many bags, condoms were found. So at the beginning, the education department made a fuss, and one of the authorities said that in order to buy a condom, you have to show age proof of 18. Like you have to show some age proof, like a driving license or Aadhaar card or something, to buy a condom. He just made that statement. Immediately, everyone jumped on him and said that how can you make a statement like that? First of all, you should be happy that these young children know what a condom is and are engaging in safe sex. If you don't provide condoms, does sexual activity stop? No. It's just that sexual activity will become more unsafe. So it will mean more teenage pregnancy, forget that. It will mean more sexually transmitted diseases in that very young population and also the older population. So thankfully that measure didn't go through, and you still don't need to show age proof and buying condoms, but that is the way society reacts. Now, the reason why the government took a more rational stand and said no, we will not ask for age proof is because they understand that children are sexual beings and sexual activity can start very early in age. It may start later, but sometimes it also starts earlier. And it understands that such sexual activity should be protected. Children should be given talks on safe sex. They should be provided with condoms. Okay? The POCSO, unfortunately, as a legislation, does not understand that. Though its intention was initially good to ensure that children are not violated, and there was law to protect girl children, which is the rape law. There was no law protecting the boy children. There was section 377, but it had a limited use. So the POCSO, the idea is good, that you are preventing children from being harmed by adult men, or in rare cases adult women, and that is fine. But there is no flexibility in the law for the agency that a child has. For the child to decide, okay, I want to kiss this boy or kiss this girl, it could become a POCSO offense. There are so many cases where school children have kissed each other, where cases have been filed under POCSO. There have been cases in schools where girls have become pregnant, where the school doesn't know what to do. They don't want to harm the girl or the boy. So they just ask the girl to drop out of school and do the 10th standard or whatever privately, or to come back after some time to rejoin. And then they say that, oh, she is in bad health. Because the problem with POCSO is that there is also mandatory reporting. You have to say, if you get to know, any person gets to know that a child has had sex, including the child herself or himself, which is so ridiculous, has to immediately inform the police. Has to inform. It disrupts everything. Parents get to know, you have to inform. If you are a counselor, the child has spoken to you about it, you have to inform. If you are a doctor, you have to inform. So it completely violates the child's sense of privacy. So then the child will not inform. So the child will not inform. And this is the problem with POCSO, that it sees it pretends as though once you have a law, everything will stop. Nothing stops, but you have just made it more difficult for children to access education and to access medical care, both. Okay? There is a recent case of the Supreme Court which says that if a child wants to have medical termination of pregnancy, then don't file a case under POCSO, don't force the child to say who the father of the infant is, because the child needs access to abortion services. But that's a law nobody knows about. And most children need so much help other than the abortion services. It still doesn't exempt parents and others from reporting the matter. So, these are the difficulties that are there with regard to POCSO. So, it's not really understanding the fact that children might be free agents in many of these cases. So, some of the other cases which we had, which demonstrate this difference between public and private, is domestic violence, which is a classic example. Earlier, the only remedy for domestic violence is crime and punishment. Now, when a woman complains of domestic violence, there would be just herself as her witness. But the husband would have himself, his parents, his brothers, his sisters, the neighbors, the servants in the house, the cats, the dogs, everybody as witnesses against this woman. The woman would just have herself. So criminal procedure was completely flawed because it had to take into account the special nature of the violence such a woman faced in the private sphere. Which is why you have 498A, which makes evidence slightly easier, okay, for immediate relief at least. The other remedy that was provided by law was matrimonial law. Earlier there was only judicial separation even if she faced cruelty. In Hindu law, for instance, only judicial separation was possible. But now she can also get a divorce. But most women who face domestic violence don't want to use 498A and they don't want the divorce. What do they want? They want to save their husband, the alimony. Most of them, when someone's beating you, what is the immediate need? Okay, to protect yourself. Okay? No, you can't slap someone stronger than you. To just escalate matters. Don't get a knife. That's not long time. So right now, if somebody's beating you, what do you want? Huh? You just want that violence to stop. Exactly. And that's caused around the Domestic Violence Act. You have a stop violence order. One of the common forms of violence was a husband would throw the wife out of the house and say, you go, often in the middle of the night. And wives who would go back and try to go back to the house, he'd say that this is my house. You are only here, you're a trespasser if you come here without my permission. And some courts actually said, how can the wives re-enter the house? That's such a ridiculous thing to do. That means anyone can throw anyone out in the middle of the night. So the Domestic Violence Act came up with a set of orders which were useful for women, like stop violence order, residence order, maintenance orders, and so on. So if you compare the other two, looking at things from a criminal law perspective or looking at things from a matrimonial law perspective, the Domestic Violence Act is much more helpful because it gives women what women want. They want the violence to stop, they don't want a divorce, they don't want a criminal case against their husband, they just want to live peacefully and with sufficient protection in that house. Okay? So it took so long, like 2005 was the Domestic Violence Act. It took so long for the law to realize that this is what women want. Criminal law does not work, but this is what women want. Sometimes we come across laws which we have to ask ourselves, are these laws really useful? To give you an example on the Domestic Violence Act, I don't know if I told you the story about one of my friends who went to give a talk on Dowry Prohibition Act. No? So she went to give a talk like this. They invited her to come and speak on the Dowry Prohibition Act. So she said, okay, this is a closed room. Please be very truthful. How many of you think that taking dowry is wrong? Everyone raised their hands. Then she said, how many of you know that giving dowry is also wrong? Everyone raised their hands. And she said, in how many of your families or extended families dowry has been given or taken? And everyone raised their hands again. So she said, you know that Taking dowry is wrong, giving dowry is wrong, but you're still giving and taking dowry. So why the hell have you invited me here? You know, what is the purpose of this, sensitization or dowry prohibition act? So that's exactly what we see. That sometimes you have these laws which have not really made inroads into society, which have not really stopped the way that people act. Okay. So before the Dowry Prohibition Act, there was another provision in the Indian Penal Code which still exists in BNS, which is called extortion. So what is extortion? Can anyone give me just briefly see what extortion is?
Alimony is one sort of extortion.
Alimony is not extortion, alimony is maintenance.
Exerting undue influence over someone to try and get money out of them.
Exerting undue influence on someone to get money out of them. So basically, putting someone in danger, like saying that if you don't give me money, I will harm your daughter. That is extortion. So what do you do if somebody says, if you don't give me money, I'll harm your daughter? You will give money because you want your daughter to be safe. But unfortunately, if this person is your daughter's husband, and he says, you give me money, others will harm your daughter, and you give money, okay? Both of you become punishable for giving and taking dowry. But in extortion, only the person who extorts becomes punishable. So some laws, like even the Dowry Prohibition Act, they don't completely understand why do people give dowry? Not because they want to give dowry, but because they want their daughters to be safe. They don't want harm to their daughters. And it's a very real harm. There have been so many cases where, because of the dowry not being given, women have been harmed and even killed, as you know. Okay? So you will try to prevent that by paying money. For the Dowry Prohibition Act punishes the giver and taker, but of course, the giver is punished much less than the taker. So to that extent, it recognizes. But it makes no sense to punish the giver because the giver is helpless. You don't have an option but to give. Okay? Any questions? The other is a more recent law which you must have heard of, which is Muslim Women Protection of Rights on Marriage Act. How many of you have heard of this law? Okay, what does the law do?
Bans triple talaq.
It
Bans triple talaq.
It bans triple talaq one. What does it also do other than banning triple talaq?
It allows to seek alimony from them.
Everyone can seek alimony from their husband. Okay, maintenance, not alimony. Anything else? What's the difference between maintenance and alimony? Maintenance is a much smaller sum meant for the woman to be able to survive. Okay, alimony is often a big lump sum. It's not a monthly payment, and it is usually given. It is more by agreement, but sometimes it can also be given by court. The strange part about this law is that it penalizes triple talaq. Now the law did not need to ban triple talaq. It has already been done in a number of cases, right from Shami Mahara's case many years back to the most recent Shaira Bano's case, etc. But this is a very strange law because it makes giving a divorce a crime. That is so strange. Nobody else makes giving a divorce a crime. And if you look at it, there are other forms of instantaneous divorce. Like in Hindu law, if you look at section 29 of the Hindu Marriage Act, customary divorces are still protected in Hindu law. And in different places there are customary divorces that are instantaneous, if your customer allows it. Like there is Solpatti in Maharashtra called Chot Chitti in Chhattisgarh, which is basically the man gives a letter to the woman saying your divorce. That's a customary divorce which is valid in those communities. Not all of Maharashtra, only the communities which recognize that. Those are instantaneous divorces. But men who give those instantaneous divorces, they are not punished. Okay? So this law then only penalizes Muslim men. For what reason, I don't know. Okay? So we see that sometimes when you look at these laws, which criminalize things which are supposedly for the benefit of women, but which are set in the realm of criminal law, there is no meaning to these laws at all. Similarly, increasing minimum age of marriage to 21 in Himachal. Nobody asks what is the average age of marriage in Himachal. What is the percentage of child marriages in Himachal? In a state like that, why are you having a 21-year minimum age? Not to help women, but to control women. Because by the age of 21, almost every large numbers of women are already married. So it's to ensure that women don't go and get partners on their own. They don't go and marry whom they want to marry. That parents are allowed to control not just children till the age of 18, but also adult women. So these laws are not helpful to women. These are actually harmful, okay, to women. And this is something that we see reiterated in modern trends in criminal law. You look at the MTP Act, the Medical Termination of Pregnancy Act, some of the requirements it places makes it slightly difficult for women to claim abortions very easily. And there are a number of laws which impact religious freedom, especially if women are involved. They are called the Freedom of Religion Acts. But if you read them, you will see that they're actually taking away freedom of men and women to marry. We see that soft targets, which are intersectionalities, are not always recognized. So, women who face violence from, certain castes or minority communities, you don't find them being addressed in the same way as other women. So there's a lot of noise, and we mentioned this the last time I was here, in the Nirbhaya case, because she was from a middle class, a prominent group, young woman living in a city like Delhi. But where there are women from minority groups, where there are women from the non-forward caste, so to say, you see that the same attention is not given to them, okay? And their rapes are not treated with the same level of seriousness. We also see that because of an aging population, which is now happening in India, there are increasing crimes against older women, especially, which are not really coming into the picture. There is no procedural justice for women, along with the substantive justice. So you have severe underreporting of all crimes against women. There are often no penalties for crimes against women, especially in the private sphere. Often women are re-victimized through the court process because it takes a long time. She's forced to then settle the matter, or she is not able to, she has to keep repeating what happened to her again and again without getting sufficient help, which affects her. And she can't afford a good lawyer in many cases. And even sentencing has a gender bias. There's a very interesting study, I think it was probably done by Prof. which showed that where there are penalties given, the death penalty given for the death of an individual, it's much more likely to give where death penalty is given where it is a killing of a man, and much more rare if death penalty is given for the killing of a woman, especially if it happens in the home. So husbands killing the wives very rarely get a death penalty. So there is a gender bias in sentencing, and there are scholars in India who have written about the same. So what we need to do is to continue to be critical of criminal law. Though criminal law can play a very important role, in some senses it still continues to have a very strong gender bias. So we need to roll back the bad criminal law, to tweak the existing law that exists, to make it more equal, and to bring in new laws and procedures. So when we talk about a rule of law, it also should include a gender-just criminal law.